Chapter 2, Provisions applicable to all companies. Part A, Formation and Incidental Matters. Section 6, Right to form a company. One or more persons may form an incorporated company under this Act. Section 7, Types of companies. 1. An incorporated company may be A. A company limited by shares. B. A company limited by guarantee. C. An unlimited company, or D. An external company. 2. For the purposes of subsection 1. A company limited by shares is a company which has the liability of its members limited to the amount unpaid on the shares respectively held by them. B. A company limited by guarantee is a company which has the liability of its members limited to an amount that the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. C. An unlimited company is a company which does not have a limit on the liability of its members, or D. An external company is a company as defined in Section 329. 3. A company limited by shares and an unlimited company shall for the purposes of incorporation be registered with shares. 4. A company of a type specified in subsection 1 may be a private company or a public company. 5. A private company, other than a company limited by guarantee, is a company which by virtue of its constitution A. Restricts the right to transfer the shares of the company, if any. B. Limits the total number of the members and debenture holders to 50, not including 1. Persons who are genuinely in the employment of the company, and 2. Persons who, having been formerly in the employment of the company, were while in that employment, and have continued after the determination of that employment to be members or debenture holders of the company. C. Prohibits the company from making an invitation to the public to acquire shares or debentures of the company. And D. Prohibits the company from making an invitation to the public to deposit money for fixed periods or payable at call, whether bearing or not bearing interest. 6. Where two or more persons hold one or more shares or debentures jointly, they shall, for the purposes of subsection 3, be treated as a single member or debenture holder. 7. A company which is not a private company is a public company except a company limited by guarantee which has a membership of 50 or less. 8. A company limited by guarantee shall not for the purposes of incorporation be registered with shares and shall not create or issue shares. Section 8. Companies limited by guarantee. 1. A company limited by guarantee shall not be incorporated with the object of carrying on business for the purpose of making profits other than making profits for the furtherance of its objects. 2. Where a company limited by guarantee carries on business for the purpose of making profits, other than for the furtherance of the objects of the company, the officers and members of that company who are cognizant of the fact that the company is so carrying on business are jointly and severally liable for the payment and discharge of the debts and liabilities of the company incurred in carrying on that business, and the company and those officers and members are each liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the company carries on chart business. 3. The total liability of the members of a company limited by guarantee to contribute to the assets of the company in the event of the company being wound up shall not at any time be less than the amount of money specified in the application required for incorporation. 4. Where in breach of subsection 3, the total liability of the members of a company limited by guarantee is at any time less than the amount specified in the application required for incorporation, every director and member of the company who is cognizant of the breach is liable to pay to the registrar an administrative penalty of 500 penalty units. Section 9. Conversion of company limited by shares to company limited by guarantee. 1. A company limited by shares may be converted into a company limited by guarantee if A. The liability on any of its shares is fully paid. B. All the members agree in writing to the conversion and to the voluntary surrender to the company for cancellation of the shares held by them immediately before the conversion. C. A new constitution, appropriate to a company limited by guarantee, is adopted by the company pursuant to Section 30, and D. A member agrees or the members agree in writing to contribute to the assets of the company, in the event of the company being wound up, to an amount of money not less than that prescribed by subsection 3, of Section 8. 2. On delivery to the registrar for registration of a statutory declaration by a director and the company secretary confirming that the conditions of subsection 1 have been complied with, the registrar shall issue a new certificate of incorporation to the effect that the company is limited by guarantee. 3. From the date stated in the certificate. A. The company is converted into a company limited by guarantee. B. The shares in the company shall be validly surrendered and cancelled despite the provisions of Section 58, and C. The members of the company who have not agreed to contribute to the assets of the company in the event of the company being wound up cease to be members of the company. 4. Except in accordance with subsection 4 of Section 21, the company shall not change the name under which the company was registered before the conversion. 5. The omission of words A. PLC, Public Liability Company, or B. Ltd, Private Company Limited, as the last words of the name of the company after conversion shall not be regarded as a change of name. 6. If the registrar is of the opinion that the name under which the company is registered would be misleading or undesirable on its conversion to a company limited by guarantee, the registrar shall, in accordance with subsection 6 of Section 21, direct the company to change its name and shall not issue a new certificate of incorporation until the direction has been complied with or cancelled in accordance with that subsection. 7. Until a new certificate of incorporation is issued under subsection 2, neither the surrender of the shares of the company nor the agreement to contribute to the assets of the company in the event of the company being wound up shall take effect. 8. The conversion of a company, pursuant to this section shall not A. affect the rights or obligations of the company except as mentioned in this section, or B. render defective any legal proceedings by or against the company. Section 10. Duties of promoters. 1. A person who is or has been engaged or interested in the formation of a company is a promoter of that company. 2. A person acting in a professional capacity for persons engaged in procuring the formation of a company is not a promoter of that company. 3. The promoter shall, until the formation of a company is complete and the working capital of the company has been raised, A. Stand in a fiduciary relationship to the company. B. Observe utmost good faith towards the company in a transaction with the company or on behalf of the company, and C. Compensate the company for any loss suffered by the company by reason of the failure of the promoter to observe utmost good faith. 4. A promoter that acquires property or information in circumstances in which it was the duty of the promoter as a fiduciary to acquire the property or information on behalf of the company, shall account to the company for the property or information and for the profit which the promoter may have made from the use of that property or information. 5. A transaction between a promoter and the company may be rescinded by the company unless, after full disclosure of the material facts known to the promoter, the transaction has been entered into or ratified on behalf of the company. A. By the board of directors of the company, if all the directors of the company are independent of the promoter. B. By all the members of the company, or C. By the company at a general meeting at which neither the promoter nor the holders of the shares in which the promoter is beneficially interested have voted on the resolution to enter into or ratify that transaction. 6. A period of limitation shall not apply to proceedings brought by a company to enforce a right under this section. 7. In proceedings under subsection 6, the court may relieve a promoter in whole or in part and on the terms that the court considers fit from liability if in the circumstances, including lapse of time, the court considers it equitable so to do. Section 11. Pre-incorporation contracts. 1. A contract or any other transaction purporting to be entered into by a company before the formation of the company, or by a person on behalf of the company before its formation, may be ratified by the company within 18 months after the formation of the company. 2. On ratification under subsection 1, the company shall become bound by, and entitled to the benefit of, that contract or that transaction as if the company has been in existence at the date of that contract or other transaction and had been a party to the contract or other transaction. 3. Before ratification by a company, the person who purported to act in the name or on behalf of the company is, in the absence of express agreement to the contrary, personally bound by the contract or other transaction and is entitled to the benefit of the contract or other transaction.